Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Morning, it is Monday, June 29th, 2026, 9:00 a.m. Let's call the regularly scheduled meeting of the Board of County Commissioners to order. Roll call, please.
Perry Buck.
Here.
Lynette Pepler.
Present.
Kevin Ross.
Here.
Jason Maxey.
Here.
Scott James.
Here. Let the record reflect that 4 county commissioners are here and 1 is present. What is the difference? Minutes. I'd ask for approval of minutes from June 15, 2026.
Move to approve. Second.
Motion by Commissioner Buck, second by Commissioner Pepler to approve the minutes of June 15th. Further discussion, please. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Need a motion to read the code
Mr.
ordinance.
Chair,
2020.
move to read code ordinance 2026-10 by audio.
Second. Thank you. Motion by Commissioner Ross, second by Commissioner Maxey to read code ordinance 2026-10 by audio. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion passes. Certification of hearings. These are the hearing certificates from June 15, 2026. They include number 1, application for hotel and restaurant county liquor license with 1 optional premises biennial renewal and permit application and report of changes from register to a manager for Rodeo Dunes LLC DBA Rodeo Dunes.
Mr. Chair, I move to approve the certificates, hearing certificates from June 15th, 2026.
Second.
Motion by Commissioner Buck, second by Commissioner Maxey to approve the hearing certificates. Further discussion? All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Are there amendments to the agenda, Houston?
Not that I'm aware of.
Thank you. I'd ask for a motion on the consent agenda, please.
Mr. Chair, move to approve consent agenda.
Second.
Motion by Commissioner Ross, second by Commissioner Pepler to approve the consent agenda. Further discussion? All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Under new business general, number 1 is to consider standard form for Weld County Public Safety Communication Service Agreements and authorize the chair to sign agreements consistent with said form. Good morning, Tina.
Good morning, Commissioners. Tina Powell, Public Safety Communications. This first item I'm presenting today is a request to approve a contract template for our dispatch user agreement that we have with all of our agencies we provide dispatch services for. This was submitted via pass around and approved to be added today by all 5 county commissioners on June 17th. I will be bringing 40 of these agreements to the board, and this template will increase efficiencies in that process. Our ask today is approval of the agreement as a template and approve the chair to sign future documents.
Questions for Tina or a motion, please?
Mr. Chair, I move that we approve the resolution. Second.
Motion by Commissioner Buck, second by Commissioner Pepler to approve the resolution. Further discussion? All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Number 2 is to consider standard form of memorandum of understanding for Weld County Regional Communications Channel sharing for use and authorize chair to sign memorandums consistent with said form. Tina.
Thank you, Commissioners. Tina Powell, Public Safety Communications. This item I'm presenting is a request to approve a contract template for our FRCC radio channel sharing MOU. This was submitted via pass around and approved to be added today by all 5 county commissioners on June 17th. This allows public safety agencies outside of Weld County to have access to our radio channels. Our ask today is approval of the agreement as a template and sign future documents.
Questions for Tina or a motion, please?
Mr. Chair, I move that we approve the resolution as presented.
Second.
Motion by Commissioner Maxey, second by Commissioner Buck to approve the resolution. Further discussion? All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Number 3 is to consider contract ID 10855, amendment number 3 to services agreement for system upgrade agreement. System upgrade agreement 2 to add NJC radio console and authorize chair to sign for Motorola Solutions, Inc.
Thank you, Commissioner. This item I'm presenting is approval of amendment number 3 to our FRCC Motorola SUA. This was submitted via pass around on June 11th and approved to be added today by all 5 county commissioners. This amendment will formally add the radio consoles in the jail and the court to our maintenance agreement. The 2026 cost is $11,693. Our ask today is approval of the amendment and request the chair to sign.
Questions for Tina or a motion, please?
Mr. Chair, I move we approve contract ID 10855. Second.
Motion by Commissioner Buck, second by Commissioner Pepler to approve contract ID 10855. Further discussion? All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Number 4 is to consider contract ID 10856, amendment number 4 to service agreement system upgrade agreement 2 to add Westminster and Broomfield sites and authorize the chair to sign for Motorola Solutions, Inc. Tina.
Thank you, Commissioner. This final item I'm presenting today is approval amendment number 4 to our FRCC Motorola SUA. This item was submitted via pass around on June 11th and approved to be added today by all 5 county commissioners. This amendment will formally add all of Westminster radio consoles and the Broomfield EOC console to our maintenance agreement. The 2026 cost we will bill to Westminster is $51,579. And Broomfield, we will bill $19,045. Our ask today is approval of the amendment request the chair to sign.
Questions for Tina or a motion, please?
Mr. Chair, move to approve the resolution as presented.
Second.
Motion by Commissioner Ross, second by Commissioner Buck to approve contract ID 10856. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Thanks, Tina.
Thanks, Dean.
Number 5 is to consider declaration of certain equipment as surplus property, authorize sale of same at auction with Roller and Associates, and delegate authority to controller to sign any necessary documents. Chris?
Morning, Commissioners. Chris Video Accounting. For you is a list of items set to go to auction. Replacements have been placed in service, and we recommend your approval.
Questions for Chris or a motion, please?
Mr. Chair, I move we approve the resolution. Second.
Motion by Commissioner Buck, second by Commissioner Pepler to approve the resolution. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries.
Thank you.
Thanks, Chris. Number 6 is to consider contract ID 10886, memorandum of agreement to purchase, is this right? Yeah. Purchase property interest for acquisition of special warranty deed and temporary easement for County Road 74 and 31 intersection roundabout project. Accept property conveyance of same and authorize chair to sign all necessary documents for Don Anderson, Inc. Good morning, Val.
Good morning, Val Mino, Public Works. Public Works is acquiring 5.257 acres of right-of-way and 3.55 acres of temporary construction easement from this landowner. An initial offer amount was supported by the Board of County Commissioners on a pass-around dated April 14th, 2026. The negotiated compensation for the landowners is $124,889.30. This amount is included in the 2026 Public Works budget.
Questions for Val or a motion, please?
Mr. Chair, I move to approve contract ID 10886.
Second.
Motion by Commissioner Pepler, second by Commissioner Buck to approve contract ID 10886. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Thanks,
Thank
Val.
you.
Thanks, Val.
Number 7 is to consider temporary closure of County Road 29 between State Highway 392 and County Road 74. Good morning, Amy.
Good morning, Commissioners. Amy Mucci, Public Works. Colson Excavating and Public Works are requesting this closure to begin on July 20th and go through October 30th. This is the final phase of the road improvements for this section. It will complete the road work and final paving. Message boards will be placed in advance as well as throughout the closure. Local access will be coordinated and the detour for this closure is paved.
Questions for Amy or motion, please?
Mr. Chair, I'd move to approve the temporary closure, please.
Second.
Motion by Commissioner Ross, second by Commissioner Pepler to approve the temporary closure. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Number 8 is to consider extension of temporary closure of County Road 70 between County Roads 49 and 51. Amy.
Public Works is requesting to extend this closure from the original opening date of July 10th to July 17th. There was a delay in construction. This is for a redeck of Bridge 7048A. The closure began 1 week later based on a utility conflict with another project, and there was an essential piece of equipment that was on that project that couldn't be transferred over to begin this one. Advanced warning has been updated, and there are no other changes to this closure.
Questions for Amy or motion, please?
Mr. Chair, I'd make a motion that we approve the extension of the temporary closure of County Road 70 between 49 and 51.
Second.
Motion by Commissioner Maxey, second by Commissioner Buck to approve the extension of the temporary closure. Further discussion, please. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries.
Thank you.
Thanks, Amy. Number 9 is to consider entry upon various lands by a Weld County Vegetation Management Specialist. Good morning, Tina.
Good morning, Commissioners. Tina Booten, Public Works. Under the Colorado Weed Management Act, CRS 35-5.5-109 and Weld County Code Chapter 15, Section 15-2-20, I must seek approval for right of entry from the Board of County Commissioners to enter upon private land to carry out weed control measures. In front of you, you have a list of 2 landowners that we may have to carry out enforcements on. I am asking for your approval to enter upon these lands.
Questions for Tina or a motion, please?
Mr. Chair, I would move to approve the entries and the resolution as presented.
Second.
Motion by Commissioner Ross, second by Commissioner Pepler to approve the resolution. Further discussion, please. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries.
Thank
Thanks,
you.
Tina.
Thanks,
Thanks,
Tina.
Tina.
Number 10 is to consider appeal of decision by Department of Public Works to deny right-of-way permit application for Soul Fiber. Morning, Director Hall and team.
Morning, Commissioners.
Curtis, Matt, you're up. Who's up, please?
Good morning, Commissioners. Matt Conroy, Assistant County Attorney. I can clear my throat. Yes, this is an appeal. Generally on section 2-4-10 appeals, the appellant goes first, but staff
Oh.
is here. If you would like us to present first, we can do that. But
Thank you. Well, let's stick with parlance. I'm assuming, sir, that you are representing the applicant, please.
One thing that I might just mention,
Bruce,
not the applicant, the appellant.
the appellant. Thank you. Getting my parlance correct. The appellant, please, if you would be so kind. Sure can, yeah. Down here, I believe, is where they do it.
Chairman, the distinction between here and present is still sticking to me.
Never been able to figure that one out. I think present is probably more proper, I would imagine.
Go figure.
But I'm here.
But I am here.
I'm here.
Such a.
I bet you Google will know.
Somebody will know. Some AI somewhere to tell me how to live my life.
Also, I think many of you have seen presentations by me before, and I tend to use gratuitous animation.
Yeah.
So that's just the.
That's- Thank you, sir. You'd be so kind as to give us your name and address for the record, and your appeal, please.
Certainly. My name is Todd Messenger. I'm an attorney with Fairfield and Woods PC in downtown Denver at 1801 California Street, Suite 2600. And I'm here on behalf of Soul Fiber, which is attempting to lay a conduit to connect Cheyenne, Wyoming with Denver metro area. And this is an appeal of a Public Works Department decision on the permitting for said fiber line. So just by way of background, our client Soul Fiber is a regional infrastructure developer that offers conduit, dark fiber, and optical transport services to telecom companies and governmental entities. As a legal matter, that makes Soul Fiber a telecommunications provider. And I apologize in advance. How many lawyers are behind we have one lawyer behind the podium. Yeah. I'm going to have to go over a bunch of technical legal stuff. I hate to do that, but given the circumstances, that's what we have to do today. Soul Fiber's project involves laying fiber optic lines and conduits from Cheyenne to Denver. We actually have, this is what Soul Fiber wants to bury in the ground. They dig basically a 4 to 7 inch trench with a vibrating plow, shove this down in it, cover it up, compact the earth in one motion. It's called a cable plow is the piece of equipment that they use to bury this. So this is what we're talking about, and it sits vertically like this in the trench. So the Weld County portion of this project is about 55.84 miles long. It's proposed to be located within County Road right-of-way between the outer bank of the roadside ditch and the fence line. So way outside of the traveled way and on the other side of two meaningful slopes from the traveled way. So short history, on October 8th, 2025, Soul Fiber approached the county with a right-of-way permit application, and 240 days later, on June 5th, we got a written denial of that application. And this is what we heard in that written denial for the first time, is that staff wasn't authorized to give consent at all anyway. And so we spent 8 months discussing the matter with staff, but it's only apparently this board that can grant the application. So in their denial letter, staff gave the following reasons for denying the permit. First, that they didn't have the authority to grant the permit in the first place. Second, that the plans must be stamped by a professional engineer. Third, that motorists and mowers may be at risk from subsidence along the line and in the vault locations and that HS20 vaults would be required. Fourth, that Soul Fiber must survey adversely possessed county right-of-way. And fifth, instead of one permit for the 55.84 mile project, county staff wants to process one permit per perpendicular crossing and one permit per run between those crossings, which you understand would be 30 permits. County staff also advised that Soul Fiber would have to provide compliant traffic controls for construction, but said in the denial letter that that's not necessary actually for the approval of the project, that comes later. And we actually have one of these vaults right there on the, if we can bring that forward, just to show what we're talking about in terms of scale. And we have a handful of these over a 55-mile stretch. So that's what, there's a pit that gets dug for that. A gravel base is put down, everything is compacted, and then the vault goes down into that pit and it's backfilled in. It sits at ground level. And in our experience, those don't really ever move based on that level of installation. And that is an HS20 rated cabinet, which is what staff had requested. And I'd like to introduce, this is Harrison Farnes from Soul Fiber. We also have the engineer for the project with us today as well. So there are new items that we found in the staff presentation when it was provided to us late last week. We need to provide method statements, including compaction. Provide methods of handling traffic, which we were told we wouldn't have to do until we actually started construction. We'd have a meeting. And that at one point, staff had suggested one permit per project mile, which would have been 57 permits. Now staff is requesting 30 permits instead of one. And after 240 days of processing, resulting in a written denial of the application, for the first time we hear late last week that other details such as seed mixes would need to be worked out. So I have to go through a couple of legal slides. I really apologize for this in advance. Soul Fiber's application is Interstate Telecommunication Service, so federal law applies to this application. Under its supremacy clause, the FCC has jurisdiction if it chooses to exercise it. 47 USC section 253A provides that no local regulation or legal requirement may prohibit or have the effect of prohibiting the ability of any entity to provide interstate or intrastate telecommunication service. The courts have interpreted this to be adding undue burden is prohibiting. County requirements must be competitively neutral, and they must preserve and advance universal service, protect the public safety and welfare, ensure the continued quality of telecommunication services, and safeguard the rights of consumers. If they do anything else, they're not lawful under federal law. So we urge the county commissioners to grant our appeal because the staff demands are not competitively neutral. They do not preserve and enhance universal service. They're not related to universal service at all. They don't protect the public safety and welfare for the reasons that we'll go over today. They don't ensure the continued quality of telecommunication services. And in fact, they interrupt that continued quality by preventing this fiber line to be installed. And they don't safeguard the rights of consumers who would be better served by having more fiber. County staff's denial of the Soul Fiber application could result in the FCC order of presumption of the county's regulatory control over its own right-of-way pursuant to 47 USC section 253D. And we'll talk about that a little bit more at the end of the presentation. So under state law, Soul Fiber is also a telecommunications provider operating under the authority of the FCC. So state law governs the county's response to this permit application. And to the extent of a conflict where there is an area of statewide concern, state law controls over county ordinances in any event, and any conflicting county ordinance would simply have to be disregarded. CRS 38.5.5101C says that telecommunications providers have a right to occupy and utilize the public rights of way. We have provided the entire Colorado telecommunications statute and the federal communication statute and highlighted the applicable portions. We know you already have that in your packet, but the highlights we thought might be helpful. CRS 38.5.5.101D provides that the counties may not exercise police powers in a selective or discriminatory manner. And it's our position that applying standards that aren't codified is selective and discriminatory per force. 38.5.5.106 requires county consent for use of county right-of-way, and we recognize that we must apply for this permit. But the consent for the use of a public highway in the county shall be based on a lawful exercise of the police power and shall not be unreasonably withheld. That means it has to be standards-based, and that means that those standards have to comply with state and federal law. 3855-1073 prohibits conditioning telecommunications provider access to rights-of-way upon provision of in-kind services, such as performing survey services for the county that the county wants in order to find its own rights-of-way. 38.5.1071B requires fees and charges to be reasonably related to the costs directly incurred in providing services relating to the granting or administration of permits. Fees and charges must be reasonably related in time to the occurrence of such costs, and the county has the burden of proving that the fee or charge is reasonably related to the direct costs. The case law on this is that the permit review and verification that the drawings comply with building codes is the extent of the fees that can be charged, that inspections and vehicular use are not part of that. CRS 3855-1073, the county has the burden of proving, and the fees and charges shall be reasonably related, and the examination of construction plans and specs and determination that they conform to building regulations is all that the county can charge for. I don't know why that slide got duplicated, my apologies. So our argument today is that staff was obligated to issue this permit. Weld County regulates the use of its rights-of-way by way of Weld County Code 81310 at SEC and Appendix 8P, which provides the technical standards for issuance of the permit. Staff argues that 81310 requires this body to issue the permit and that staff doesn't have the power. But this board specifically gave blanket authorization to staff to process and approve right-of-way applications, including the application before you today, by way of WCC 81360A, which we quote, if the Department of Public Works finds that the work described in the application for right-of-way use permit conforms, then the director shall issue the permit. Stamp drawings cannot be required. Staff denial letter says that stamp drawings will be required for this permit. Appendix 8P requires engineer stamp plan and profile drawings for underground installations running parallel within a roadway. This is well outside of the roadway. It is specifically accepted by Appendix 8P, and there's no reason to require the additional time and expense of engineer stamped plan and profile drawings here. Because the installation is not within the roadway, this requirement cannot be applied as a legal matter, and applying an inapplicable standard is contrary not only to code, but it violates state and federal law because it's arbitrary and discriminatory by nature. The location of the proposed conduits, the plan set provides at sheet 4 that the center line of the installation shall be kept as close to the right-of-way boundary as possible. Sheet 10 of the plan set, which is typical, shows that the installation is 16 feet from the edge of the roadway and 6 feet from the right-of-way boundary, which is well within the area that's safe to plant these cables in, particularly using a cable plow. Without evidence or reference to engineering standards, staff's denial states the following. For the proposed fiber conduit, the concern would be that subsidence increases the chance that a vehicle that leaves the road rolls over due to the trench that formed. Likewise, a mower could get stuck or flipped and one of my employees injured. This is the width of the trench. I have had the great misfortune of witnessing a car traveling across a divided roadway through a ditch, taking air, landing on the other side in the ditch. And I can tell you from personal experience and saving somebody's life that the risks to the car of a 4 to 7 inch trench on the other side of that ditch do not exist. The parallel installations will be done by cable plow between the outer edge of the roadside ditch and the fence line. Cable plows loosen the earth by vibration, plow the cable in, and compact the earth over it in rapid sequence, leaving no trench at all and leaving no possibility of subsidence. A vehicle that leaves the road into the ditch will have many potential risks to face, but a parallel fiber installation is not going to be one of them. According to OSHA, specifically, riding mowers should not be operated within 5 feet of ditches, and there are material risks to mowers operating within 6 feet of a fence with wires and barbed wires on it, that if those wires were to pop off the fence, they could be wrapped around the blades of the mowers. And so it would appear that the staff concern about riding mowers should be addressed in terms of actually being that close to the ditch in the first place and being that close to the fence. We assume that your people riding mowers are following OSHA and that they're qualified to do their jobs and that they're very diligent about these items. Perpendicular crossings at intersections will be done by bore as the county requires, so there will be no impact on the surface at all in those locations. Staff had a particular concern with vaults. The vaults will be outside of the roadway. They will be installed at a minimum of 6-inch gravel bed on a compacted surface. They are HS20 rated as staff had required, and they are compliant with all applicable AASHTO load rating standards. Subsidence at any part of the installation is extremely unlikely, and if it were to occur at all, it would be so slight that it wouldn't create any risk. I'm going to invite Harrison Barnes up to explain what you're seeing in the following photographs, and then we'll close after that.
Hello. So what you're seeing here is a installation that was performed last year along I-94 in Montana. As you can see, there is a vault in the photo, and what you cannot see is under the surface, there is 3 of these individual conduits. And as you can see, there's no subsidence. There is also no issues with reclamation. This is another photo, much of the same, taken along a county road in Billings, Montana, that was performed in 2023. And as you can see, it's even better with the vegetation and no subsidence. Then here is a project that we performed in 2022 in Walcott Junction. So this would be in southern Wyoming at Interstate 80 and YO 210. And you can see in the photo all the way to the right that there is a plow line about 10 feet off of the fence line. And in the photo, you cannot tell it, but there's several other plow lines next to it. So there's a total of 3 plow lines with 3 separate underground fiber optic facilities. In the center photo, this is a directional drill, a bore that was performed under the interstate. And as you can see, there's no impact to the interstate whatsoever or the earth around it. And then the photo to the left is just more showing the plow line approaching. Then this is a intercontinental line that was installed in 1988. So for the last 38 years, there hasn't been any disruptions from the railroad track that is 30 feet away from it. And if any of you have ever sat at a railroad grade crossing, you know how much your vehicle shakes. And during that for the last 38 years, there's still no subsidence or any impacts there. I believe this is our last, okay. Then here's some just same exact vaults as you saw there installed in Casper, Wyoming back in 2023. As you can see, none of them have settled. Then this is a active project in Moorcroft, Wyoming on the I-90 business loop. And this is about a day or 2 after this was put in. And as you can see, the only items needed to be performed is setting the vaults and then going through and putting down the appropriate seed mix. And I will pass it back to Todd.
So the next term that the county staff demanded in their denial letter was that the applicant and here the appellant provide survey data to the county that WCR 79, a portion of that roadway was adversely possessed and the county staff isn't sure what its appropriate boundaries were. And so that staff would require Soul Fiber to survey it. We got a quote for that. It was somewhere in the range of $40,000. County staff says it's a reasonable use of the police power to not encourage trespass or adverse possession. Of course, the irony there is that the police power adversely possessed the road in the first place. But beyond that, I think the county well knows what part of that roadway it maintains, and this installation will be well within it. Moreover, county notes anticipate rights of way that don't have well-defined boundaries, and the required notes, which are in red on the plan set that's been provided to you, say show the county right of way as best as can be determined, and label distance of lines and appurtenances from the edge of existing roadways. If this has not been determined, then a note stating the minimum distance required by Weld County can be used. And for Soul Fiber, the county staff has determined that those notes are not applicable anymore, which is again per force discriminatory. If there are concerns about right-of-way boundaries, the county can allocate county resources to address those concerns. That adverse possession of that property, if the county wants to nail it down, it most certainly can do that. But having Soul Fiber do that just because it wants to lay an interstate line is an in-kind service to the county. And not only is the service, the survey condition discriminatory, but again, it is an in-kind service, and that's prohibited by state law. Again, the multiple permit requirement, which is down from 57 to 30, is inefficient, but it's also unlawful. County staff suggested in the denial letter that applications should be filed, and it's a favor to Soul Fiber to do it that way in manageable chunks for each perpendicular crossing and for each segment of parallel installation between those crossings. That's not 57 permits, but we'll concede it's 30 permits where only one permit is needed. Today, county staff's presentation says that Soul Fiber needs to submit separate applications to facilitate accurate review and inspection. Now, I would offer that if I have to submit one permit application with standard drawings on it, and then the route and so forth, if I have to break that into 30 permits, I have 30 times the redundancy, I have 30 times the application fee, I have 30 times the amount of production that I have to do from the engineer side or whoever's drawing those drawings. And then I have to track 30 permits. That doesn't sound very efficient to me. Turning one comprehensive application into dozens does not make it more efficient or accurate. It just increases application fees, production and processing time, and the chance for error. And the resulting fees are unlawful because they're not reasonably related to the cost directly incurred in providing services relating to the granting or administration of the permits. The contention that waiving unlawful fees is itself unlawful is incorrect. State law plainly controls the county regulations in the event of a conflict, and the state law which we provided to you says that this is an area of statewide concern. So that preemptive effect is as a matter of law there. County staff's offer to refund part of the fees at some point in the future, made for the first time in the denial letter, doesn't fix the problem. Because first, the excessive fees are not reasonably related in time to the occurrence of the costs. And second, county staff misapprehends the lawful scope of the fees in the first place, so we'll just be arguing about what the refund is. Per unit and per foot fees are unlawful. The county's construction fees may apply well to culverts and other infrastructure, but with respect to telecommunications facilities, the permit fees on a per foot basis and on a per structure basis are unlawful under Plains Co-op Telephone Association, Inc. versus Board of County Commissioners of the County of Washington, in which the court directly invalidated such fees. This is what the court said, the Colorado Court of Appeals. Section 3855-1071B allows only a narrow type of permit fee. A permit fee normally defrays the costs and services to be rendered in the examination and construction of plans, specifications, and to determine that they conform to building code regulations. That's it. Not vehicles, not inspections. And the court actually recognized that there are areas where the cities and counties can do more, but the legislature has determined that this isn't one of them. So our request for relief today is pretty straightforward. Soul Fiber respectfully requests that the Board of County Commissioners reverse the denial and direct the county staff to accept the level of detail in the plan set that you have before you, so that the remainder of the project's run can be submitted with the same level of detail and we can get that permit issued. Upon submission of those plans for the remaining extent of the project, direct staff to issue a single right-of-way permit for the same within 10 business days. We expect that Thursday will provide a complete plan set. So a week later and the following Monday would be the deadline for that. And then waive the per foot and per unit construction fees because they are unlawful. Soul Fiber further requests that the Board of County Commissioners find that no further method statement is required, and we can have our engineer explain how the plow compacts the earth and takes care of all the issues that staff was worried about, and that no other details need to be worked out. Of course, the concern here is that you return as a board the application to staff for processing and approval, and we spend another 240 days working out details. We don't have that kind of time on this project. The project has all kinds of other contractual obligations associated with it, including issues with scheduling in the federal government. So today, we've also provided to you a courtesy copy of a petition that we intend to file with the FCC today or tomorrow. The Soul Fiber project has a rigid timetable, and we simply can't afford additional time beyond that 10 days anymore. And so because that process has gone on for 8 months, we have no meaningful choice but to concurrently petition to the FCC for preempting Weld County's authority. But if the county staff timely issues the right-of-way permit, Soul Fiber will happily voluntarily dismiss that petition with the FCC. And with that, we're here to answer any questions. And if you'd like to know more about the engineering, we're happy to bring our engineer up here to discuss it.
Questions for the appellant, please?
I have a couple. Thank you, Mr. Chair. Mr. Messenger, thank you. A lot of details. Just a couple questions. And maybe you mentioned this, so if I ask you a question to repeat, then I apologize. Do you hold a certificate of public convenience and necessity from the Colorado Public Utilities Commission?
So Soul Fiber does not have a CPCN, but the concurrent run interstate infrastructure group, they do have a CPCN, and their conduits will be going in this plow as well. Soul Fiber is also authorized by the FCC, and the FCC petition has all the licensing information that you would need. So under state statute, Soul Fiber is a telecommunications provider.
So, okay, thank you. And I'm reading from our code here is where I'm getting this. So how does Soul Fiber meet the requirements in CRS 40-1-103?
41103, we can bring
Which
that back up.
defines what a public utility is, which our code allows for parallel installations in a public right-of-way. So we allow parallel installations under 41-103, but that's under a definition of what a public utility is that actually serves the public.
So the state law on this, going back to, give me just a second to. So Soul Fiber is a telecommunications provider. So this is controlled by 3855-101 at SEC. So the state law controls the local ordinance, and the county must allow telecommunications providers to occupy and utilize public rights of way under reasonable, codified, non-discriminatory provisions.
Okay, thank you.
Additional questions for the appellant, please? Please.
I want to push back on that a little bit, Mr. Messenger, so maybe you can give me some background. You're claiming you're a telecommunications provider. Under what authority have you been granted that title, or is that just how you're choosing to label Soul Fiber itself?
So Soul Fiber meets the definition of telecommunications provider under state and federal law. And in fact, the state definition kicks you from this section to another section of state law to a federal law for that definition. Soul Fiber has authorization by the FCC for the interstate lines. And there's a Fifth Circuit case that is very, very persuasive. We're in the 10th Circuit, of course, but there's no 10th Circuit law on this that says that even a provider of dark fiber that contracts with something that's licensed as a telecommunications provider is a telecommunication service. So Soul Fiber meets all of those requirements, and Interstate Infrastructure Group, which has its own physical lines in this plow, also meets that requirement.
Additional questions? Curtis, Matt, and Tina.
Thank you.
I don't know, just however the. Oh, okay, so you have the presentation or? The other PowerPoint?
You'll have to pull it up.
Oh.
If you have it on your computer, you'll be.
Okay. Sure, that actually. Good morning again, Commissioners. Matt Conroy, Assistant County Attorney. To my right is Curtis Hall, the Director of Public Works, and to his right is Amy Mucci, Permits Coordinating. What's your title again? Sorry, Amy, I forget.
Permit coordinator.
Permit Coordinator for Public Works. Okay. First, because it came up in the Soul Fibers presentation, first I want to talk about the federal law. The section of the statute that Mr. Messenger did not cite is 47 USC 253C, state and local government authority. Nothing in this section affects the authority of a state or local government to manage the public rights of way or to require fair and reasonable compensation from telecommunications providers on a competitively neutral and non-discriminatory basis for use of public rights of way on a non-discriminatory basis if the compensation required is publicly disclosed by such governments. And then to the point about an FCC complaint, there 47 USC 253D does say, if after notice and opportunity for public comments, the commission determines that a state or local government has permitted or imposed any statute, regulation, or legal requirement that violates subsection A or B, the commission shall preempt the enforcement of such statute, regulation, or legal requirements to the extent necessary to correct such violation or consistency. Notably, this section does not include subsection C, which we are managing our right of way in this case. So I don't believe there's any grounds for an FCC complaint. Now, moving to state law. This did also come up in the direct presentation. The Article 5.5 does not authorize any telecommunications provider or broadband provider to erect within a political subdivision any poles or construct any communications or broadband facilities, including small cell facilities and small cell networks, conduit, cable, switch, or related appurtenances and facilities along, through, in, upon, under, or over any public highway without first obtaining the consents of the authorities having power to give the consent of the political subdivision. And of course, as the board knows, the entity who has the power to give Weld County's consents is the Weld County Board of County Commissioners. And this also come up, we need your consents. If you choose to withhold it, needs to be based on a lawful exercise of your police power, and you shall not be unreasonable in withholding consent. And also you cannot create any preference or disadvantage through the granting or withholding of your consent under statute. And you shall not discriminate, but also you shall not give a preference to competing telecommunications providers or broadband providers. As for the fees, the statute says that no political subdivision shall levy a tax fee or charge for use of a public highway other than a street or public highway construction fee, to the extent that such permit fee applies to all persons seeking a construction permit. So the fees that staff are saying that this is what the Weld County Code imposes are the same fees we charge every single project and every single telecommunications provider on the same basis. And so in general, and so there's also this discussion of in-kind services. Soul Fiber is correct that we shall not require the provision of in-kind services as a condition of consent to use a highway. And we do not believe that it is requiring in-kind services to give us an accurate description of where you're going in the right-of-way, including where the right-of-way boundary is over a 56-mile project, right? This isn't requiring a service such as, oh, move this other trench or like co-locate it or something while you're building yours in. It's simply saying, where are you going so we know what we're consenting to. And then I think also in terms of reasonableness of the Weld County Code, staff's interpretation of Weld County Code is that Section 8-13-10 does not list telecommunications providers as a sort of automatically that staff can grant a permit, which makes sense because you get these 56-mile long projects, and it should really stay with the Board of County Commissioners on whether or not to make the decision to give the county's consent to the installation of this project. And so we think that this is a completely reasonable requirement, and it's perfectly proper under the Weld County Code and the right-of-way permit code to require a denial. It goes in front of the board. We do this all the time with other permit types. There's no issue there. And so the Department of Public Works condition or position is that we believe that this board should consent to this project, but we do need that there needs to be some conditions of that there needs to be sufficient plans for sufficient method statements, including how compaction is going to work, that they will provide methods of handling traffic moving forward, which I don't think there's any disagreement on, but we do need to make sure we're on the same page of how this project is going to look, because it's going to take a lot of staff time. And as such, we do think that they need to pay the appropriate fees as laid out in the Weld County Code. My advice is that the appellant overreads Plain Co-op Telephone Association Incorporation, which is, that case is really an evidentiary ruling, as Soul Fiber mentioned. They, in the events of a dispute on the reasonableness of our fee, and we end up in court, obviously the county will bear the burden of proof of saying that our fees were reasonably related to our costs. What Washington County did in this case was they said that all of the evidence they put on was that their fees were related to the cost of future damage to the roadway. That's why they did their lineal foot, and not about, I don't think there's any reference in the case to, oh, inspections aren't under it, are not required as a proper construction fee. And we think that that is a very much part and parcel of any permit. Is you issue the permit that say, what are you going to do? And then you inspect it to say, did you do what you said you were going to do? And so based on our expectations for, again, a 56-mile long project, we think that the $161,000 is about what it will cost. And we also, this sort of goes back to the point about the appeal methodology, right? So this board is aware there may be an ask for seasonal employees or something if the board approves this project, which is no problem. The Soul Fiber would be on the hook for the actual cost of the county, but that's sort of the way it would work from a staffing perspective. And so I will turn it over to Ms. Mucci to discuss what we think sufficient plans would look like. And so I'll turn it over to her.
Okay. Good morning, Commissioners. Amy Mucci. So this started out, basically the first part of our process is just getting a sufficient set of plans. We did have an initial meeting with Soul Fiber on October 14th. They kind of gave us an overview of what their project was. Seeing the immensity of it, we even discussed in that first meeting that we would be reducing the number of permits, but it is important to have sections, because each segment is going to be different, have different considerations, different conditions, going to be different traffic plans, different reseating requirements. We talked about method statements, but again, it was a general overview. We've never really got into all the details just because we never got through the set of plans. My suggestion was we started with 79. That's why County Road 79 is being so heavily talked about today, and none of the other sections, is because let's get this one good, and then you'll have a template for the rest of them, for the rest of your permits. So the main problem that we have with 79 is there's notes in there that are very generic. The way they show their alignment, they're very close. They're very close from where we started. The first set that I saw, this set's very close, other than we have specific notes that call out that the right-of-way is 80 feet. We know, and there is lots of documentation out there, that the right-of-way is not 60 feet, or excuse me, not 80 feet in that section, it's 60 feet. If my team were to issue, or myself would issue a permit for this, I'm allowing them to be 10 feet into private property. The same thing with having generic, that every bit of the line is going to be 6 feet off the right of way and 16 feet from the edge of pavement. You can't make that promise. There's going to be other utilities, other things that they're going to run into. So it would rather be one or the other. They're either going to be 6 feet off the edge of the right of way as much as they can, and just give it a better basis. But if we're going to go with exact numbers, then we have to ask for more exact data. How did you come up with 80 feet of right of way? Because we don't have it. And again, I'm comfortable issuing a permit that they're going to stay within the right-of-way boundaries, and they show that even if it's more generic form. I gave a lot of examples. We permit hundreds of fiber optic permits every year. There's examples of everything from a rural, which they fall under a completely different set of requirements, on up to AT&T, who is putting a project in very similar. They're going to have 31 crossings. They are running on private, but they still are getting all their crossing permits, including non-maintained section line and roadways. So I think that's where we're at. We never were able to get a good enough set of plans to even proceed with the rest of it. I think once we get a decent set of plans, I mean, we did talk about engineer stamp plans simply because we weren't getting anywhere. Over 8 months, showing examples, giving explanations, we weren't getting what we needed. We know that they're working with CDOT, and we did have a meeting that included CDOT. CDOT showed what they were going to expect. We gave that as an option. If you do the same thing that you're doing for CDOT, we'll absolutely accept that. But again, we can still work with these. There's an option to work with it. There's not a question of if they can be there or not, but we do have to have that information. We have other projects in the areas. The reason that we break up our permits the way we do is they're not going to be the only one out there. We have other applicants out there. We have different landscapes out there. We have steep embankments. Some of those, there's 3 feet of right of way for them to work in. They may not be able to plow in those sections. They may have to change. We can have those discussions knowing that. Driven the whole line, I have photographs and documentation of the whole 56 miles. So we can help them with that. We can also coordinate when we have other applicants out there that also need to utilize the right of way and may already be there. I think that we have different road types as well. We go from paved to gravel to full depth mag chloride. There's different conditions on how traffic control is going to have to be managed on each one of those, just based on the amount of traffic and different speeds. I think we also have a lot of farming to the edge of the road, which is sometimes a misinterpretation of how our right to farm, but we support that. We have crops in place right now. So again, in those areas where we can be aware of that, we want to make sure that a good conversation is had with those farmers. So either soul fiber could place after those crops are done or before they replant, so that we can coordinate that.
Questions of staff, Commissioner Max?
Thank you, Mr. Chair. Amy, thank you, and Curtis, Matt, thank you very much. So just real quick question. If I heard right, you're not disputing the fact of them being in right of way, though? You're saying that they can just submit proper information.
Correct.
And submit the information consistent with what we require of other applicants, pay the fee that we require of other applicants. It sounds like we're being very consistent with that approach. And I know I can speak from a very, very close experience that a road crossing generally is considered one application, so that you look at that bore underneath that road as an individual crossing permit, regardless of the parallel aspects outside of that road crossing. So that to me has been very consistent for many years that I've been here at the county. So I just want to make very certain that I'm hearing that right, that being in the road right of way is not necessarily under dispute right now.
No, it's
Okay.
not that. It's just their position in it. We need to be clear that
Okay.
again, I'm not issuing a permit that allows them to trespass on private property.
Okay, sounds good. I appreciate that clarification, because there's a big part of me that wants to say, why not just go in private? Just work with an easement. I mean, in the future, if we expand the roadway, then we're paying to move your easement and the line. And under this case here, there still would be that stipulation that if they're in the road right of way and we do a road project, they're on the hook for moving it.
That is correct, Commissioners. And early on in the October meeting that we had with them, that was one of the first questions Amy asked, is had they done any investigation to go in their own easement outside of right of way, and that seemed at that meeting to be pretty much a non-starter. They did not want to go down that path. They wanted to be in our right of way. That's when we started working with the Soul Fiber to try and come up with something. Their original plan set was basically a GIS rendering with a thick line just showing that they were coming down 79, 77, a little bit on Highway 14, then back down 79, I think to 74, and across to 89 and then across on 52 and on into Morgan County. Amy's staff could not decipher exactly where they were at in the real world on that original set of plans. Amy provided actually, told them what we needed. They came back with pretty much the same plan set. She provided them then with the examples that you see in your packet, and they came back then with the latest that they've had, that they were very close, but we didn't hear from them for quite some stretch. And then they've re-engaged lately prior to my denial letter. And at the last meeting, when we pointed out a few things that they needed to correct, that they were close, they said they were done. That was it. That was the permit you were going to get. And that is why I gave them the denial letter. If they were not going to do anything but what they'd already submitted, there was no reason to try to keep working with them and to get this process in front of you guys. We've never said that this should not go in right of way. Once they provided the set of plans that had the 80-foot of right of way that we know does not exist on 79, it's pretty easy to go onto the county's website, look through survey stuff, get book and page number of what the actual right of way is. It's 60 foot. They put some lines on the drawing. They don't even need to label 60 foot, but just show us, hey, we're going to be within county right of way. Then that, wrong wording that Amy's team would actually allow them to permit an 80-foot right of way that they could actually be on private property goes out the window. The answer to I think Amy talked about the engineered stamp drawings. That was never necessarily a requirement, but in the time frame early on when we weren't getting anywhere, and when we had CDOT in the room and they CDOT laid out what they needed, we said, if that's what you're providing, that will work for us. So it was never you must. It was, hey, that works for us. If that's the direction you want to go with the rest of your project, to simplify it for you guys, that you're not providing us with something completely different than what you're providing CDOT. That would work just fine for us. The issue of the plowing and the vaults, we had never even got to a point that we could discuss because they hadn't provided the right plan set. Some of the issues that they were talking about in the compaction, what they're doing around the vaults when they dig up a hole. You saw how big that vault was. They're not going to be able to just dig a hole the size of that and place it. They're going to obviously dig up bigger than that. We don't even know how they're going to compact around that in this dry climate we've got. Are they going to use water to compact it back so there isn't subsidence? And then for the trench itself, same reasoning. Is it, if it's dry out there and the trench does compact, I'm not saying a vehicle traveling 80 miles an hour off a side of a roadway is going to have a lot more to worry about. But I'm talking about the person that's driving on the roadway and then has to pull off for a flat tire, and they pull off far enough that they can maybe change a tire, and then they end up in a trench that's subsided and they're stuck there, or they actually damage their vehicle in our trench. But I think all of those things are easily done in future talks with them as we get forward. Again, Amy just started providing them with, here are some things to start thinking about in the future. The compaction, the seeding that you're going to do to, combat whatever piece of equipment. I'm assuming most of these are tracked dozer type of machines that they're plowing the cable in with. I'm going to assume that's what they're doing. We don't absolutely know yet, but that's going to chew up our landscape out there that in this year is probably not going to come back very quickly at all. So we just need to know what their plan is to restore our right of way. On 77 that they're planning to go down, we have 2 open CDPHE permits that they're going to have to work with us, because they're going to be disturbing ground that we have put back and are on the hook for. So they will Lindsay's doing the research on that piece right now to figure out how we can handle that so that they can either take over that piece of the permit, or we can at least, as Weld County, you guys won't get fined by CDPHE for disturbance that their team does. Trying to go through some of the things that they talked about during their presentation. Amy's done a very good job early on, again, talking about, hey, we'll reduce the permits rather than a per mile like we've done with everyone else. She's broken it down into road segments. So all of 79, all of 77, are their own, all of 136 are all their own separate permits. And that is because, 77, has some challenges, but it's a pretty wide open, a few culverts. Once they turn down 136, they're going to be going through Hereford, and then they hit Crow Creek, where we have a bridge that spans pretty close to the edge of the right of way. And we need to know how they're going to handle that so that they don't end up impacting our structures that are in place along 136, 77, and on down into the gravel road section. Some of the gravel road sections have very steep back slopes, as you guys, as we've gone out on tours. They're very steep, sandy back slopes. I'm really not sure how they're going to handle those areas to try and plow in a trench. But again, I think we can get to a point where we can get this doing. We just need to sit down and get a plan set for each segment of roadway that Amy's team, who is very good about working with folks of getting their permit through and getting them working as quickly as possible. I think we can get there. We just need them to actually be able to work with us and not just keep throwing up. We've done this all across the country, and we're gonna hold up our FCC stuff, and you guys just need to let us come and do it. If you have any more questions for me, commissioners.
Commissioner Russ.
Few questions. Curtis, you hit on some of it. I apologize. So I look at page or sheet 6 of 27 from the presenting party this morning. I don't know if you have that information in front of you. It shows a bore, and it's different than what the denial party showed us here earlier. I mean, I'm not a real smart guy with math, but as I counted, what was in his package is different than what I see on both examples here on page 6. And then I don't know if that's what you guys have been presented. What are we looking at for how many conduits they're running in this bore or pull that they're doing here?
So the bore and the running line are the same number of conduits. There's 8 is what they showed in the submittal to us. It looked a little different than the piece that he brought out, but I'm sure it's similar of how they're going to install it. But they were showing us 8 conduits. And then on the bores, they put that in one larger conduit. It'll be a 10-inch bore underneath the roads. And these are the linear segments, and then those would be the bore crossings. Those would be the road crossings that we would need.
And that's where some of my confusion is in the inconsistencies of what's been brought forth and then what we have in paperwork. And apparently that's kind of what you guys are seeing as well. How many crossings, how many road crossings are we looking at total?
So the total road crossings are, is it 21? 21 crossings.
States there on the,
Yeah.
on the sheet. Okay, so as I go through their evidence or submittal they provided to us prior to coming up here, I'm challenged as to see how they're going or what they're doing as they go through those crossings. I'm not seeing whether that's a bore, whether they continue to trench. Sorry for my confusion, but it's not explicitly laid out in some of the evidentiary stuff brought forth today. Did you guys get better idea of what they're going to do at those crossings?
Yes. So in some of their conversations, and it's hard to see on their design because it's so small, they do change colors. Their intent is to bore all those road crossings.
Okay.
We had that discussion early on. They were agreeable to that. We also had discussions that we require all accesses to be bored regardless. We don't allow them to trench through folks' accesses.
Perfect.
Unless they have a permission with that landowner, that's okay, but they were agreeable to do that. that they would bore all accesses to not impede people's access or for safety, getting in for fires, things like that. So that was their intent. Their trench lines were mainly their running line in between roads. And they do show some boring. It looks like it matches up to things that I saw in the field where there might be groves of trees that it limits them from being able to plow.
Thank you for that clarification. I appreciate it, and sorry for missing that. Has it always been our understanding that they were doing the vibratory trench puller versus cutting an actual trench?
Yes, I believe that it was my impression that they would be using a puller and a plow.
Okay, thank you.
And that's typical, that's standard. There's different types of machinery for that. I haven't seen what their machinery looks like.
Okay.
Our initial plan set though did show their trench being this way, what they presented to you this morning. Now they went this way with what they're doing. So that's a difference that we saw for the first time this morning.
Let's talk about, I think the gentleman that presented, Mr. Messenger, talked about how there's no settling in those types of trenches. Have we experienced settling in those types of trenches in the past? Because as we talk about safety issues, I have my own experience with that, and I guess I'd like to see Public Works, your comment towards that.
I'll let Amy speak to
Commissioners,
this.
they almost always settle. That's why we ask what type of compaction they're going to be using to ensure that it doesn't. But there's a good chance that when we're this dry, then we get rains, especially a heavy one, it'll follow that trench line. Hence the reason in our code we have a 2-year warranty of workmanship so that we monitor this. We're not just going to be inspecting while they're installing the line. The inspectors will have this on their path for the next 2 years as they go through checking these areas, because sometimes it does happen. Especially depending on how fast the revegetation comes in. If we get stabilization quickly, it's going to hold better. If it doesn't, it's just a natural path. It's an easy path for that water to follow. So we do see it. It's over the years, we've had them, several companies have to come back, have to fix an area, bring in some material, compact it down. So it does happen.
If that has settled, right? Like we've witnessed in the past. And to use Mr. Director's, Hall's example, regardless of whether that trench is setting vertical or it's setting horizontal. In your estimation, does it pose a safety threat as vehicles exit the road unexpectedly? Is that something tires can get caught in and provide a potential rollover hazard? Mr. Messenger stated it is no hazard. I believe was his comments. And so I just want to hear from our Public Works team on that stuff.
I would disagree that does present a hazard, not only to the traveling public, but to my team that's out mowing those roadsides with tractors and the mowers behind them, especially around these boxes. If they haven't been compacted well, as you know, it's not like it's a nice mowed off surface that they're in. Typically we've got grass and weeds that's 2 to 3 feet tall sometimes, especially around disturbed areas. And my tractor might not be able to see that, end up in one of those areas that were dug out around one of their boxes or even in a trench.
Another thing he brought up as we're talking about mowing, so thank you for bringing that up, Director Hall, was OSHA applicability. Are we held to OSHA applicability?
So I think a fundamental misunderstanding on that point was Soul Fiber was discussing riding lawnmowers. As the director just said, we do not use riding lawnmowers, we use tractors. And so just sort of we need to understand and be on the same page of what the facts on the ground are. And that's just what we've been struggling with, is we cannot agree on what the facts are.
Commissioners, if I may add too, keep in mind this trench is going to be 5 feet deep. So again, we saw a little appliance, but that little appliance has to go in the ground 5 feet deep. So again, that's why the compaction is important, because again, when they're plowing that in, just that method shakes the ground around. Again, if there are failures, that small trench can turn into a bigger one if there was an erosion concern.
Okay, thank you.
Additional questions?
Bruce, is it appropriate to offer the appellant an opportunity to rebut, or have we heard?
Yes.
We've heard. Mr. Messenger, any comments?
Thank you, Mr. Chairman. I do believe that one of the issues of this is that the ground does keep shifting. I was personally involved in 2 calls with staff. And some of the things that we heard today, we heard for the first time. And to the extent that there's an error on the plans that says 80 feet of right of way and it should have been 60, that wasn't brought to our attention as this should be 60, not 80. And this is why you have a problem. It was, you need to survey our right of way for us where it was adversely possessed. As an officer of the court and owing a duty of candor based on my own attorney ethics, I represent that I saw that happen in real time. With respect to the bores, the typical bore is shown on sheet 6 of 27, and the bores are shown in terms of their locations in the plan set across all of those driveways. With respect to the representation of 47 USA CA 253, the federal law about removal of barriers to entry, the preemptive effect applies for violations of subsection A or subsection B. Subsection A, I've provided you a copy of this law that in this document here. And reading along, no state or local statute or regulation or other state or local legal requirement may prohibit or have the effect of prohibiting the ability of any entity to provide any interstate or intrastate telecommunications service. That was part of my presentation, and I believe the representation of this statute was inaccurate, and that the FCC certainly has jurisdiction here, and the FCC's choice to exercise that jurisdiction will be up to the FCC. I would submit that the FCC preempted local governments on small cells and dictated the process for review of small cell infrastructure. As a guy who also represents local governments, I was put off by that. I don't think the FCC is interested in turning back from its imposition on local regulatory systems. And with respect to the Plains Cooperative case, we also provided you a copy of that. And I think that the representation underreads this. We highlighted on the 3rd page of that case, the operative language of this. And the case cites to McQuillan, and it cites how a permit fee normally defrays the cost of services to be rendered in the examination of construction plans and specifications and to determine that they conform to building code regulations. And that's it. So you can't go further than that. And so with respect to the fees, the issue here with multiple permit sets, as convenient as staff may represent that, is it ends up escalating the administrative cost. It ends up escalating the cost to the applicant and the time involved, which gets into prohibiting the occupancy of the right-of-way in a reasonable and non-discriminatory way, which could lead to FCC preemption. We have heard many, many different positions from staff along the way here. Our client intends to provide a corrected plan set on Thursday, then provides the entire run and provides the 60-foot right-of-way and includes that detail with respect to how that right-of-way is going to be handled. The representation that the ditch could collapse in, that the 7-inch bore could collapse in, think about that for a minute, about what that would mean for the earth on the top. And it's not going to create a 5-foot hole. There's still earth in that pit. And with respect to driving off the road, 16 feet, I think it is, off the road? 16 feet off the roadway, down an embankment, potentially up an embankment on the other side. It's not a risk to the traveling public. We had been given the information that the staff would be in trouble with their riding lawnmowers. It wasn't represented to us that staff used tractors, but if they use tractors, think about your own experience. This is Weld County. We know what tractors look like. A 4 to 7-inch little trench along the way, if it has minor subsidence in it, is not going to take a tractor out. Tractors have big tires. That doesn't make any sense. So at the end of the day, I think we're getting speculation without reference to standards, without reference to code. We're being asked to provide engineer stamp drawings because CDOT said that they would want that? No. What the staff said is we must provide engineer stamp drawings, and today they walked that back, probably realizing that the code doesn't actually allow them to require that. And I don't want to speculate about motives or intent. That's not the right thing to do. But what I would say is the county cannot, under its own code, require professional stamp drawings. It wasn't a courtesy, and the rationale for those drawings was not provided to my client or to me in the 2 times that I had met with staff and the attorneys on this case. So we respectfully request that this board grant this appeal and clear the way for this project to move forward, and we will provide a conforming plan set on Thursday. Thank you. If you have any questions, we're more than happy to answer them. And we have engineers here who can answer any questions that you may have about safety.
Mr. Chair.
Please, Commissioner Buck.
Well, sir, from what I'm hearing, it's not that we don't want to work with you. We have standards that we've put in our code that we believe can stand the test of time for all the ones that have come before you in terms of telecommunications.
Mhm.
The fact that we are not meeting in the middle, to me, seems like we could do a better job. Your company could do a better job just from what we heard from the changes from going in this way to this way. Tractor versus lawnmower. It just seems like we're not on the same page. And I would ask you respectfully is if you could take more time to meet us in the middle, because it's not that we want to deny your project, but we would like to make sure we're all on the same page, which I don't think we are today. And it's not like we haven't worked with telecommunication companies prior. So I ask you, would you be willing to do a continuance?
Thank you for that, Commissioner. I believe the problem is that we're 8 months in to this process, and we still haven't figured that out, apparently. We have been given mixed messages along the way, and we didn't detail them because we didn't want to take your whole day on appeal. But at one point, we were told that our project is speculative infrastructure and it wouldn't be allowed at all. There is a profound misunderstanding of state and federal law and how it affects this project. And there is a profound misapplication of Weld County code because most of the things that are being asked of us have no basis in the code. And so the ball keeps moving around. And it's fair to say that there are errors on this plan set. You know, I'm going to concede that when I looked at it, I expected to see 60 feet of right of way and I saw 80. And, you know, I put my head down and thought about it and said, we will produce a conforming plan set on Thursday, as we promised. And then if the county can review that in 10 days and we can get to yes, that's great. That's what we should do. But having a moving target when you're an applicant is very difficult, and just as it's very difficult when you're staff. The difference is that staff has a set of standards in Appendix 8P that it applies to these applications. And what we're hearing is things that are outside of those standards. And when it's outside of those standards, it's per force discriminatory because it's by necessity arbitrary. And that's a violation of both state and federal law. So yes, we want to get to yes. Nobody wants anybody to get hurt. And yes, we will realign the cables, as my understanding, for more closer to a 4-inch trench than a 7, because they work better vertically, apparently. So we will make some updates to the plan set that will address some of these concerns. But what we're asking this board to do is not make us go on for another 240 days before we get another letter and changing grounds and more demands that don't have anything to do with the code and that violate state and federal law. The application fees that are allowed to be charged are set by the case law interpreting the state law. We don't have any discretion over that anymore. The number of applications being multiplied from 1 to 30, no matter what staff says about it, doesn't make any sense. The traffic plans will be submitted prior to construction and can be segmented. That's not an issue. We will provide MUTCD compliant traffic control on each segment, and we will coordinate with staff as they desire so that they can have different plans in place for each reach of that. Mostly, though, we're going to be off of the road on the other side of the ditch. And with respect to, you know, driving tractors in that space or whatever, you know, there's still issues with mowing on that side. And we hope that everybody's doing it safely. I trust that they have been. And, you know, the idea of having a tiny trench next to an actual ditch, it just doesn't, I have seen this. It is ugly when people land in the ditch. You probably have all seen people land in the ditch as well. What's on the other side of the ditch is barely relevant when you get in a car accident like that.
I'm just going to go ahead and push the envelope and ask you, how much time can you give us to hopefully all come together? How much time?
I would leave that to my client and I'll bring him up here to answer that question. We do want to work with the county and we do want to dismiss the FCC petition. We do want to do that.
Thank you.
Commissioner Max, before I get to you, Bruce, if I can ask, you know, we're litigating process here. We're talking, this board's decision is pretty simple. We uphold the denial, we overturn the denial. I mean, all this conversation of process is that something that we consider here, or we simply uphold the denial or overturn the denial?
correct. You either grant the appeal
Right.
or you deny the appeal.
But you can't do it in continuance?
No, I
You could, but
guess the thing is that you want to continue the appeal to do what?
To see if there is a better communication, because I think it's missing, sir.
Okay, they've presented their facts. We've presented our facts.
Mhm.
And they've gotten a reply, a rebuttal. Now you need to make a decision. I mean, this is not one of those where, hey, we continue it and then they can work on it.
Commissioner Maxey.
Well, I guess I have a question for Mr. Messenger here, but I mean, I guess that's a good point to make, Mr. Chair, is that if we deny it, what does that mean for the project? I mean, if a denial
Deny the
of the appeal means that they have to stay with what our staff has told them and the project moves forward, is that what we're talking
Well,
about?
our staff has essentially denied the application.
That's what I'm wondering. So
Right.
that means the project is then
Is denied, and then I'm assuming that the appellant would have other
reapply.
avenues for relief, or where they could reapply, or they can
reapply, right?
challenge us at a higher level.
They could do that.
What's the
Challenge
time?
it at a higher level or reapply?
I take exception to the fact that you come in here and you say, you make your presentation about the appeal, and then you say, oh, by the way, if you don't grant what I want, we're going to sue you.
Yeah.
I
I see that as
That's
a veiled
what you
threat.
did right here. Okay? That's
Which is-
what you're doing.
And I agree, I don't take kindly to threats, so I would appreciate, if you
Inappropriate.
want to file with the FCC, that's on you. You don't have to wave at our face, or,
File at any time.
Mr. Chairman,
please do.
if it please the county commission, I have the utmost respect for Mr. Barker. We have worked constructively for years. I love this guy, even if he's mad at me. He's a
Well,
great guy
Your
and a great
motion
county
tonight,
attorney.
you're addressing this board and not
Yes.
necessarily our council.
Thank you, Mr. Chairman. This is not a threat with the FCC petition. We are out of time. We have a contract with the federal government. We have other obligations, and we
None
have,
of
this
that
is
is
in the
my
middle of a
concern,
bigger. I understand, Mr. Chairman. With respect to the FCC petition, we don't have time to wait to then file that because they have their own notice period. They have their own comment period. And if we have to wait through that sequentially, we will not make the project schedule. And that's why we had to do it. And it is with regret that we did that. And we would love to have that dismissed. And it is not a threat. It's just the situation that we find ourselves in 240 days after the application.
And what does that have to do with the matter that you have before this board?
What it has to do is we're providing you a courtesy copy. We don't like surprises any more than the county should of the FCC petition so that you have
But
it.
it has no merit to.
You
the
come in
predicament.
here, we tell you, you don't, the threat is unnecessary, and you say, sorry, I'm going to continue to threaten you. I'm
No.
sorry, I'm done listening to the appellate, Mr. Chair.
Commissioner Maxey, please.
I guess I just have, I mean, maybe it's a comment, maybe it's a question, and then I'm kind of in the same boat. But Mr. Messenger, I mean, I hear what you're saying. I initially thought that this was an appeal because we were saying no, nowhere, no how be in our right of way. It is not that type of an appeal. We are saying you can go there. We just need certain parameters that, again, in my personal experience working with this department, there are certain parameters that are consistent across the board, whether it's a pipeline company or a electrical company or a fiber optic company. So I guess I'm struggling with, you're sitting here saying that we should make exceptions for your company to not follow our normal process for the fees, for the number of permits, when we're saying this is standard process for us. Comments back saying the right of way is wrong, and then saying that wasn't brought to your attention ahead of time. It's incumbent on the applicant to make a accurate application in front of us. And doesn't surprise me one bit that our staff replied back to say, it's not right, go back and do it again. So I guess I'm just, maybe that's just more of a comment babbling on here a little bit, but I guess I look at what you're asking us to do is say, treat you special. And I don't understand how you can get up here and advocate for that when we have kept our process consistent with a variety of different right-of-way users. So again, I don't know if you want to comment for just a second, but I'm kind of at the same place where Mr. Ross is at.
Exactly where Commissioner Maxey is. Sorry, Mr. Chair, I'm going to jump in. We change our process for one applicant, which is what they're asking for. And he's talking about discriminatory processes towards them. It now becomes discriminatory against every other applicant we've had in front of us because now we have not been consistent in our process and how we go about this. And sir, what you're asking for is outside of the lines of what we have consistently done with multiple other applicants prior to you and others that are engaged with us consistently right now. And that is appalling to me.
Mr. Chairman, may I address the board?
Please.
Thank you, sir. With respect to the telecommunications aspects of this, under state and federal law, those are qualitatively different from oil and gas pipelines, from electric utilities and all of that. There is a very specific portion of the Telecommunications Act that governs this, and a state implementation of that Telecommunications Act with this law that we provided to you. It does not apply to gas pipelines. It does not apply to electric utilities. It is very specific, and the controlling case law on telecommunications services is different. The state law says this is a matter of statewide concern. There is plenty of case law that says in a matter of statewide concern, the state law has preemptive effects. We are not asking to be treated special. We are asking to be treated as the state law requires, and the state law is preemptive. We didn't want to file a petition with the FCC, and so I mentioned that when we talked about it, that we didn't like to have that out there. I don't like to personally come into a commission and say, I'm going to sue you. It's a bad look, but we ran out of time.
Well,
We're
Mr.
200, I'm sorry.
Mr. Messenger, I can appreciate what you're saying here, but I have had personal experience working with a pipeline. Granted, they're two different things. Working with a pipeline that is regulated under FERC that have worked more quickly with us than what you guys have worked with on us. So they could come in and argue the same thing, that they don't have to get any sort of county permit, but it's a matter of being a good neighbor and working with the entity that is here to have accurate information, which also helps us with future planning efforts for future roadways and other planning cases that come before this board. So I guess I'm a little bit torn about you relying on that when it comes down to working with each other. And it seems very one-sided. Again, I'm going to repeat the fact that I think you're asking for exceptions right now, regardless of state statute. You're coming in here and asking to be treated differently.
Commissioner, we are asking to be treated in accordance with state law. And what I would say about the nature of this appeal is this is a very interesting circumstance to me, and I didn't actually know how to present this. I got to be honest with you. Staff represented to the board that they had asked for us to get one segment of this project down to a set of plans that the staff could approve. So we have one segment of an overall project, and we are asking this board to say those plans are good enough, correct them, get the right of way correct and whatever, but the level of detail in that plan set is sufficient with a typical bore, with the engineering, with the proper, all of that, which we have and will provide. Okay. That denial was issued apparently because staff came to the conclusion that the introductory text of the Weld County Code that pertains to right-of-way permits said that this body, not staff, had the ability to grant this permit or not, which is, we think, inconsistent with subsection 70, which has a different approach to it. And so we were shocked that it took 8 months to be told that this would have to be decided by the board. We could have resolved this 6 months ago in those circumstances because not a lot has changed over that time period. It has been very difficult, and I have worked with your staff before, and I appreciate your staff. And I appreciate that in your position, you want to listen to staff because those are the professionals that you've hired to carry out these administrative duties. And I do not like to roll staff under a bus. But when I'm told that a 4-inch trench that's 16 feet away from the roadway is a hazard to motorists, that sends my radar up. In this particular case, I would just urge the board to consider the logic behind that. I think staff is wrong about this point. And even if they're not, the variability in what this applicant has been told, in my personal experience, in all candor to the board, you can't have this project at all because it's speculative infrastructure. Well, here is a CPCN for our co-partner on this. We are approved by the FCC for interstate lines. We are a telecommunications provider. We have a statutory right. And that was what we said before we were told that it's speculative infrastructure. So this record is not pretty. And we would like to just ensure our request for full relief isn't just, hey, we want you to reverse. It is, hey, we want you to reverse and remand with directions that we get this done quickly. That's all we're asking. Because if we get remand without that direction, or if we say we uphold and we're going to grant this anyway, the question is when? The federal government is relying on this project. We need to get this done. And so we just ask that we have a better relationship because those meetings were painful, I must say. Typically, I'm not a guy to get aggressive at a meeting. And there was aggression at those meetings on both sides. People got their backs up. It was not okay. And we need to get to yes on this because it's important regional infrastructure. It's important national infrastructure. It's good for Weld County because it will provide fiber optic services to the east where those could be used. I mean, ranching is sophisticated now. Having fiber optic infrastructure in the road is a good thing. We want to have fiber optic infrastructure in the road. The state wants fiber optic infrastructure everywhere it can get it. That is a matter of state policy. And we are, taking 240 days to get from an application to a contentious board hearing about it. That's not okay. We need to work together, but we need to have a timetable for that. And what we're really asking for is that timetable. And the only reason that FCC petition is out there is so that we have some kind of something if that timetable isn't met. Because if we wait until that timetable doesn't get met to file that, it's going to be too late because the FCC has its own timetables. So we respectfully, didn't want to do that. We just didn't want to do that. I'm not a guy that threatens litigation. I either file it or I don't. So I appreciate the concern about it. I appreciate that it put Mr. Barker off. Again, Mr. Barker is as good as they get. I look up to him as a county attorney.
Again, I appreciate your evaluation, but the board needs to make a decision. Matt, please.
I think from my perspective, it would be worthwhile to reiterate what staff's request is.
Mhm.
And our request is that the board grants the appeal in part
Mhm.
and go back and say, yes.
Matt, you've even got a slide in there. I was hoping maybe you could roll back to that slide.
My computer to work. Right. So our position is yes, the board should grant the appeal in part, right? Because as I mentioned, the procedural mechanism is that the board can give its consent to this type of project, having heard everything about the importance of it and how do we get to yes. But that's when on remands, the board should direct staff and the appellants to submit a separate permit for each parallel installation and crossing to facilitate accurate review and inspection. This also has the advantage of it allows us to parallelize. If they can get County Road 79 way up north done really quickly, they can get that going and then move on to, and we know that there are more difficult sections of this road. And so that will allow this project to get moving. And when, I suggested that several months ago, they said, no, we had to do this all at once. And because we're trying to get this done in an efficient manner, and we think parallelizing makes sense. It works for us. It should work for them. We don't understand why it doesn't work for them. Okay. And again, my advice to the board is that a waiver of fees would be an unlawful preference to Soul Fiber. Do we have accurately portrayed them in the county code of how much we charge? Our lineal foot lineal foot format fee is different than the Washington County one in that it is related to our costs of administration and inspection. Again, Plains Co-op Telephone Association Inc. doesn't say anything about inspection is not part of the fee. It just says that damage to the road can't be part of the fee. And so today we think my advice is that we are on solid ground under statutes. I think we're on solid ground under federal law, but we should get to yes and say, do this to get your permit.
I agree with that. Director Hall.
I was just going to address a couple of the things Mr. Messenger spoke to, the timeline. There was about a 3 month, there was a 3 month at least gap in our discussions. That was on their end. Amy's team provided them with things that they needed to do, and they chose to not re-engage with us. And then when they did start to re-engage, that's when they brought their attorneys to meetings. So we obviously then have to have attorneys in the meeting as well. And I think those were not productive. However, the meetings prior to that weren't necessarily that productive either. Harrison Farnsworth's refusal to make any changes to the original plan set for a couple iterations hampered our ability to really move forward. I do believe if we were able to sit down, have discussions, we could probably get somewhere. 10 days, I'm not sure we can get anywhere in 10 days with the work that's gone gone prior unless they make a commitment to really jump in with both feet and see where we can get.
Mr. Ross?
Questions, Commissioner?
To clarify with Matt, staff's recommendation is granting of the appeal?
Grants the
With the
appeal in
conditions.
part with
With the
conditions.
conditions.
It's the, Commissioner Ross, are you looking at the same slide I am? Are those the four conditions along with the fifth one that is basically a reimbursement request? Or
Denial of the yeah, sure.
reimburse if the
Can
cost?
we go to that slide, Matt?
Yes. You want,
It's before, right there.
There we go.
That's the one I was looking at. And I mean, I'm hearing Mr. Messenger say, number one is being taken care of. Plans will be resubmitted. I think there's a little bit of rub on number two. I think that, I heard three is being handled too. And I think that four is a rub. Is that kind of what you're looking at too, or are you looking
By
different?
rub, do you mean they aren't agreeing with it? Is
Yeah.
that what you're saying,
Yeah.
Mr. Maxey?
Yeah, we're not aligning with 2 and 4 is what I'm looking at.
Yeah, but I'm sorry, I believe we need to have answers for
I agree.
2 and 4, and I don't think we're out of line asking for the appropriate fees.
I agree with you.
Well, and again,
So I'm going to move this along, Mr. Chair, unless you
Please.
have additional comments.
well, my comment was simply our role is to either uphold the denial, to overturn the denial, or uphold the appeal, or overturn the appeal. I think right there, I think that we grant the appeal with those conditions.
That's what I'm
It
going
ain't
to say
different.
in a formal motion, if
Yeah.
that's appropriate.
Please
Mr.
do.
Chair. Mr. Chair, I'm going to go ahead and make a motion. We can move this along. We can go one way or the other after the board decides, but I'm going to move to grant the appeal with conditions that staff work with the appellate and we receive sufficient plans for them, breaking that down as staff is requested in the 30-part series, as is customary for what we do. I would like to see full statements understanding the compaction and method of such, as well as the methods for handling traffic control. And I'm not willing to waive fees as requested by the appellate. And should anything be in excess, as our county code says, we will reimburse said fees as we typically do. Was there anything else I needed to add to that, Mr. Maxey? Am I missing something, Matt?
I believe that's sufficient for my purposes.
Okay, I'll stand at the end of my motion.
Second.
Motion by Commissioner Ross, second by Commissioner Maxey. Let me see if I get this right. To grant the appeal with following conditions: to provide sufficient plan. Yeah, the appellate provide sufficient plans. The appellate provide method statements, including compaction. The appellate provide methods of handling traffic. The appellate pay the appropriate fees. All right. Represent your motion correctly.
I think so,
Okay.
but you missed the last part. Should we?
County will
reimburse?
Should the county reimburse fees exceed cost of the county? There's a motion. Further discussion. All in favor, say aye.
Aye.
Aye. Opposed, same sign. Motion carries. Thank you. The chair really needs a 5-minute break. I'm sorry, Matt. We'll stand at recess till 10:43. Boy, Matt, I usually buzz through these things.
You did up until that point.
Yeah. That's a problem on that one.
I'm good, but I'm waiting on, I bet he's coming in the door now. There he is.
Matt would like to say a few words.
Okay, let's continue. It's 10:44. Record reflect all 5 county commissioners are present as we continue our meeting with Monday, June 29, 2026. We are at agenda item 11, which is to consider ratification appointment to High Plains Library District Board of Trustees. Chair will take a moment to allow Dr. Hort a couple of comments, please.
Thank you, Mr. Chair and Commissioners. Good morning. It's stand before you today to bring forward a ratification for a trustee to the library board to replace a vacancy that occurred for the remainder, or the vacancy is for the remainder of this year, just to finish out this term. So we're presenting Carmody Lee as the applicant. With that, I wanted to thank Commissioner Maxey for serving on the panel, selecting the appointee. And with that, we had a great panel of applicants. I think any of the 6 that we interviewed would have been great additions to the board. But Carmody brings a lot of educational experience. She is currently the coordinator for the educational coordinator for IBMC, and then also teaches English online at Purdue University as well, and has been in the community for quite a number of years. So she brought a lot of excitement and really a new view for the library district, which will be really great. I'd be happy to answer any questions the commissioners have.
Questions for Dr. Hort, please.
No question, Mr. Chair. I just want to say thank you. And it was a pleasure serving on that selection committee. And I'll just echo that, Mr. Chair, and the rest of the board, that it was truly, there was an impressive slate of candidates. It was a very hard discussion and debate. There was a lot of points, counterpoints, but I think the board is happy with the selection, obviously, and hopefully Carmody will do a great job. I'm sure she will.
So, additional comments from Matt, or is that a motion, sir?
Mr. Chair, I'd like to move the appointment of Carmody Lee to the High Plains Library District Board of Trustees.
Second.
Motion by Commissioner Buck, second by Commissioner Maxey to approve the resolution. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Thank you
Thanks
for
for
waiting, sir.
waiting.
Number 12 is to consider airport infrastructure grants agreement for reseal runway 1735 project, which is 43%. Authorize the chair and county attorney to sign.
Mr. Chairman, this one and then 13 are both the same thing.
Okay.
This is typical that when a grant comes from the federal government for the purpose of fixing the runway, they seek to have approval not only by Weld County, but also by the city of Greeley. So that's all this is your part of the approval and then signature.
Okay. Questions for council, or a motion, please?
Mr. Chair, I move to approve the resolution.
Second.
Motion by Commissioner Ross, second by Commissioner Buck to approve the resolution. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Number 13 is consider airport infrastructure grant agreement for a resale runway 1735 project, 23%. Authorize the chair and county attorney to sign. Ditto.
Ditto.
Mr. Chair, I move to approve the resolution.
Second.
Motion by Commissioner Ross, second by Commissioner Maxey to approve the resolution. Further discussion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. On the new business ordinances, number 1 is the first reading of Code Ordinance 2026-10 in the matter of repealing and reenacting with amendments, Chapter 5, Revenue and Finance of the Weld County Code Small Business Incentive Program. Good morning, Director. Thank you for your patience, sir.
Good morning, Commissioners. Thank you for your time this morning. We figured we'd end your meeting on a little bit of a happier note today, hopefully. With me today is Rich Werner with Upstate, who will be helping administer this program. So again, David Eisenbrown, Director of Planning Services. Ordinance 2610 repeals and reenacts Chapter 5 of Revenue and Finance to formally reestablish and also modernize the County Small Business Incentive Program. Purpose of the program is to support economic development in unincorporated Weld County only. None of the 32 municipalities will qualify for this. by helping qualify small businesses offset required public infrastructure or safety improvement costs. Eligible businesses must be located again in the unincorporated portions of the county, make a qualifying investment between $50,000 and up to $10 million to create or retain jobs, demonstrate site control, and meet wage requirements. The incentive may reimburse up to $50,000 for eligible improvements such as road or traffic improvements, stormwater infrastructure, utilities, fire suppression upgrades, or other safety and compliance improvements. The ordinance before you today also clarifies that the application review, approval, appeal, and reimbursement, including all coordination with Upstate and final review by the Planning Services Department, is to help clarify the process for both the applicant and the county. And finally, overall, this ordinance provides a structured, accountable tool to help small businesses grow while ensuring public dollars are tied to completed improvements, job creation or retention, and the broader public benefit. Thank you, and happy to answer any questions, as well as Rich may have a few comments for you.
Mr. Warner, anything additional?
Thank you, Mr. Chair, Commissioners. He went through it very in succinct detail, so I don't want to belabor the point. Just want to again thank and recognize all of you for your support of small and medium businesses as well as economic development projects historically. This is something that we have worked very hard on and will continue to provide administrative support for as we actually look at providing tangible support to our businesses that help address cost in a meaningful way, and then also will really help reduce some of those barriers for companies that are looking to start or expand here in relation to partnering with them, creating projects that will increase the value for in the future for buildings, addressing necessary public infrastructure improvements. And we thank you for your time.
Questions for staff or for Rich? This is public hearing. Chair would like to open the meeting for comments from the public regarding the first reading of Code Ordinance 2026-10. Any comments from the public? Seeing none, we'll close public comment. Ask for a motion, please.
Mr. Chair, I'd like to go ahead and move that we approve on first reading Code Ordinance 2026-10 in the matter of repealing and reenacting with amendments Chapter 5 Revenue and Finance of the Weld County Code for the Small Business Incentive Program.
Second.
Motion by Commissioner Maxey, second by Commissioner Buck to approve on first reading Code Ordinance 2026-10. Further discussion, please, Commissioner Maxey.
Real quick, thank you, Mr. Chair. I just want to say that the original Small Business Incentive Program had been around for quite a few years, I think close to a decade, if not a decade. And definitely at that time, it was a good idea. It served its purpose for that day and age. It needed to be modified. And I just want to say thank you so much to Rich and Audrey and David for all the hard work of revamping it, really making it a better program for today and what we're seeing in the business world today. And I look forward to hopefully this program providing that benefit to multiple businesses that are out there so that we can retain them or even attract them, as Rich said. So thank you guys very much.
Further discussion? Ditto. All in favor, say aye. Aye. Opposed, same sign. Motion carries. Thanks, guys.
Thank you.
On to public comment, each individual speaker allowed a 3-minute period of time in which to direct comments to the board. Chair shall reinforce the rules of order and decorum and will not accept any comments regarding matters which are scheduled to be considered at a future public hearing, such as a land use hearing. In that event, the speaker will be asked to give their testimony at the appropriate public hearing, either in person or in writing, pursuant to the rules set forth, Section 2-1-20.e of the Weld County Code. Any comments from the public this morning? Seeing none, we'll stand adjourned. Thank you.